Hey class, welcome to week 5. This week we are going to talk about the U.S. Constitution and how it applies not just to the federal government, but also to state and even local governments. Specifically, we are going to examine the Bill of Rights and two important clauses, the Due Process Clause and the Equal Protection Clause. In order to understand how we protect our constitutional rights, we're also going to do a short review of our courts and how cases move through the court system. So the U.S. Constitution, as we've noted previously, it creates the biggest limit on agency discretion. The Constitution is based, at least in spirit, on the Magna Carta. That was a charter of rights agreed to by King John of England in 1215. And the Magna Carta was drafted to make peace between the king and a group of barons who were rebelling against the crown. The Magna Carta promised protection of things like church rights, protection for the barons from illegal imprisonment, access to swift justice, and limitations on feudal payments to the crown. Now, although the Magna Carta was very much focused on the ruling class, on nobility, it really did influence American colonists, and it was used as a model for the U.S. Constitution, as well as several state constitutions that preceded the U.S. Constitution. So as we've talked about, the Constitution's first 3 articles embody the concept of separation of powers by dividing the federal government into 3 co-equal branches: legislative branch in Article 1, executive in Article 2, and judicial in Article 3. Articles 4 through 6 embody the concept of federalism by setting forth the rights and responsibilities of state governments in relation to the federal government. So the Constitution forms the supreme law of the land in the United States. And while federal and state governments can grant people additional rights, more than what is provided in the Constitution, they cannot reduce our constitutional rights. And I say people because many aspects of the federal and state constitutions apply to all people in the U.S. and also potentially to corporations, not just to U.S. citizens. The Constitution took effect in 1789. It has been amended 27 times. That includes the 18th Amendment, which established prohibition, and then the 21st Amendment, which repealed the 18th Amendment and abolished prohibition. The first 10 amendments to the Constitution are known collectively as the Bill of Rights, and they offer specific protections for us as individuals by placing restrictions on the powers of the government. I'm not sure how much experience everyone has with the Bill of Rights last time you took a civics class, so we're going to run through it now. And at the very least, it's going to be useful if you play Jeopardy or Trivial Pursuit. So the Bill of Rights is the first 10 amendments to the U.S. Constitution. Originally, the Bill of Rights was only applicable to the federal government. However, we quickly realized that restricting the federal government from violating our civil rights doesn't really matter if the state government and local governments can do it, because we all have far more interactions with our local governments and our state governments than we do usually with the federal. That, of course, is different for those of us who work at or with the federal government, but just generally in the U.S., Americans are going to have more interactions with, say, local police than with the FBI. So the Supreme Court began incorporating the Bill of Rights against the states. So incorporation is just the legal process by which portions of the Bill of Rights get applied to the states. And this happens through a mechanism in the 14th Amendment. It's the Due Process Clause in the 14th Amendment that says, "No state shall make or enforce any law which shall deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of laws." So it was through that clause that the Supreme Court began incorporating the Bill of Rights against state governments and local governments. I'm going to run through and actually show you in blue which of the cases were incorporated by the Warren Court. So that was the Supreme Court with Chief Justice Earl Warren, who was a Republican appointee to the court. But he actually, it was through his opinions in his court that we got a lot of the rights that we currently take for granted today. So First Amendment, that is the amendment that deals with our freedom of religion, speech, the press, our ability to assemble and petition the government for redress. So Congress can make no law respecting the establishment of religion, so that guarantees that the government is not going to be tied up in religion. It's actually designed as much to protect churches and other religious establishments from government as vice versa. It also permits the free exercise of religion or the lack of that exercise. Freedom of speech, freedom of press, freedom of assembly, all sort of incorporated in the 1920s and 30s. Redress of grievances was finally incorporated by the Warren Court in 1963. Second Amendment is the right to bear arms. This was finally incorporated against the states pretty late in 2010. That was actually the latest constitutional provision to be incorporated against the states until incredibly recently, and we'll just talk about that in a moment. Third Amendment says that the government can't force us to quarter soldiers. This is actually not incorporated against the states by the Supreme Court, but if you happen to live in the federal Second Circuit, that's Connecticut, New York, and Vermont, it is incorporated against those states. But unsurprisingly, the Third Amendment has never been a primary basis of a Supreme Court decision. It's really not something that we tend to think about all that frequently, but was a much bigger deal back in our Revolutionary era. So the Fourth Amendment is where we get our rights against unreasonable search and seizure. So this requires that the police get a warrant upon probable cause that has to describe the place they're going to search and the person or the items they're going to seize. And then it also just generally permits us as Americans to be free from an unreasonable search and seizure. And those rights were incorporated by the Warren Court. Fifth Amendment, a lot of times we think of it just as double jeopardy, or we think, I'm going to plead the fifth so that I don't incriminate myself. It also, though, contains a due process clause. So the Fifth Amendment gives us the right to have an indictment by a grand jury. This part is not incorporated against the states, but it doesn't really matter because most state constitutions grant that right as well to their citizens. It does protect us from double jeopardy. The government can't come after us twice for the same conduct. Now, when I say the government, I mean a single level of the government. If you do something that violates both a state and federal law, then the state and federal governments can come after you. That's not double jeopardy. But if you've made it all the way through a trial and you're found, that you're not guilty, the government doesn't get a second bite at that apple. We've also got the protection against self-incrimination, which is why you do not have to take the stand and testify against yourself. And there is also the just compensation for taking of private property. We tend to think of this as eminent domain. If the State Highway Administration is going to seize a portion of your front yard because it wants to widen the roads, it's the Fifth Amendment that requires that they actually compensate you properly. So the Sixth Amendment contains all of our various rights regarding trials. So that's the right to a speedy trial, the right to a public trial, the right to have an impartial jury, the right to know what we're accused of, the right to confront witnesses against us, the right to subpoenas so that we can compel witnesses to testify, and then, of course, the right to assistance of counsel. The Seventh Amendment is the one that everybody forgets, and this was actually one of the bizarre times when the framers of the Constitution didn't look that far into the future because they actually put down a monetary amount. So the Seventh Amendment basically says when you're suing somebody in civil court, this isn't for criminal issues, and you're owed more than $20, then you get to have a trial by jury. That obviously is not the case. It has not been incorporated against the states. It would really muck up the docket for our civil courts because $20 is just not that much anymore. The Eighth Amendment prohibits both cruel and unusual punishment and excessive fines. Historically, there's been a lot of litigation, a lot of court opinions about cruel and unusual punishment, but there's not been so much about the excessive fines. And that's been a real big issue for civil asset forfeiture, the process by which law enforcement officers take assets from persons who are suspected of involvement with a crime or criminal activity, but without necessarily charging the owners with wrongdoing. So if you see your local police officers driving around in like super fancy sports cars, there's a very good chance that those cars were seized from suspected drug smugglers during a drug bust. There has been a lot of debate about whether such seizures constitute excessive fines against individuals, particularly in light of some very egregious uses of civil asset forfeiture to take housing and vehicles away from people who did nothing at all wrong themselves, but whose family members were suspects in criminal activity. It can be really difficult to get your property back after it's been forfeited, and usually people can only recover it by paying an attorney. And even then, oftentimes it's only a partial recovery. And what this means is that poor people are far more likely to have their property seized and never returned without any type of due process, and thus suffer a greater negative impact from the loss of that property. So this was finally incorporated against the states in the 2019 decision Timms v. Indiana. The prohibition on excessive fines, the incorporation of it, received really wide bipartisan support. Even the U.S. Chamber of Commerce filed a brief in support of Timms, arguing that just as individuals can be harmed by unreasonable asset seizures, so can companies. Companies often end up incurring large fines for fairly small violations. So now, post-Timms, states are not supposed to use civil asset forfeiture or fine you in a way that undermines your constitutional rights. Unlike the prohibition on excessive fines, the Supreme Court incorporated the protection against cruel and unusual punishment back in 1962. Now, the court has been clear that the Eighth Amendment does not require comfortable prisons, but it does require humane prisons. In one of the more recent Eighth Amendment cases, Brown v. Plata, the Supreme Court specifically reminded the state of California that prisoners retain the right to be treated with dignity. Prisoners are removed from society as their punishment. They don't go to prison to be further punished or mistreated. And the Brown case focused on California's prisons, which for over a decade had been operating at about 200% of their design capacity, which resulted in horrific and really unhygienic conditions and a preventable death every 5 to 6 days. Then we move to the Ninth and 10th Amendments, which deal with unenumerated powers. So the Ninth Amendment protects rights that are not specifically mentioned in the Constitution. It recognizes that there might be other rights that are not enumerated. And the 10th Amendment delegates powers to the states or to the people where the Constitution does not specifically delegate those powers to the federal government. So why did we just run through the Bill of Rights? Federal governments and their employees are bound by the Bill of Rights. State governments and their employees are bound by the provisions of the Bill of Rights that have been incorporated against the states, and really that is almost all of the important ones. The due process clauses of the 5th and 14th Amendments require the government to treat people with some minimum standard of fairness before the government takes their life, liberty, or property. The Equal Protection Clause requires that the government treat people equally. And so what this means from an administrative agency perspective is that agency regulations can be invalidated if they violate either the due process or the equal protection clauses. And even if a regulation is valid on its face, that means it doesn't seem like it's discriminatory as written, if the agency enforces that regulation in a discriminatory fashion, that could violate the Equal Protection Clause. And this is really key in both very urban and very rural areas, as it can be easy to inadvertently treat both inner cities and rural communities differently than we treat suburban communities. Now, it's important to understand as Americans that our constitutional rights are not unlimited. We all know that we can't falsely shout fire in a crowded theater and then use the First Amendment to protect us from the consequences. Now, in addition to the varied limitations on constitutional rights that apply to all of us, government personnel face some additional limits on their constitutional rights. Government employees typically are protected by the First Amendment for their general speech and their expressive conduct on what we call matters of public concern. And that can be, political expression and is included in that. So if you work for a government agency, you can't be fired or disciplined for exercising your First Amendment rights as a citizen. Now notice though, I said typically government employees are protected by the First Amendment. And that's because even speech on matters of public concern can be limited if the speech is related to political campaigning or if it is likely to disrupt the workplace, and that disruption would outweigh the value of the speech. So that could include otherwise protected speech that creates an inefficient workplace or disrupts your colleagues. It also includes otherwise protected speech that creates a hostile workplace. So in these cases, the government must balance the interest of the employee, the government employee, as a citizen of the United States, and their interest in being able to comment upon matters of public concern. So it balances those interests with the interest of the state as an employer, and its interest in promoting efficiency in the public services that it performs. This is a very fact-specific legal analysis, and it is best left to your agency's legal counsel. There are some other restrictions on freedom of speech for government employees. On matters of professional responsibility, government employees don't have full First Amendment protections because they're acting in their capacity as a public employee, not a private citizen. So if the speech owes its existence to the employee's professional responsibilities, then the speech is made as a public employee. It is not made as a private citizen. Government employees also don't have First Amendment rights, or at least full First Amendment rights, in the workplace for speech about personal matters. And that might include, personal spats, complaints about the government as an employer, not as a government, or matters of personal interest. So if all of the water cooler chatter about fantasy football is interfering with work, your boss at a federal agency is not violating your First Amendment rights by telling you to cease the football talk and get back to work. Now, political speech is a specific component of First Amendment speech, and the Federal Hatch Act of 1939 limits political speech of government employees generally and executive branch employees specifically. The Hatch Act does not apply to the president, and it does not apply to the vice president, but it applies to most other federal branch employees, including cabinet members, agency officials, and the civil service. And the purpose of the Hatch Act is to erect a firewall between government employment, particularly within the federal civil service, and partisan politics. It wants to separate those. So the Hatch Act prohibits federal executive branch employees from engaging in political activities on the job. It also prohibits them from using their official authority or official influence to interfere with or affect the results of an election, regardless of whether they are on or off the job. So basically, if you work for the federal executive branch and you're not the president or the vice president, you can't be politically active while you're at work, and you can't throw your weight behind a candidate using your position as a federal employee. So the easiest way to avoid violating the Hatch Act is to simply not engage in any type of political activity while on the job, at your office, or when you are representing yourself in your capacity as a federal employee. Now, you may have heard a news report or two about Kellyanne Conway, White House advisor, and her violations of the Hatch Act. And while Kellyanne has apparently gotten away with violating the Hatch Act, the statute has real teeth when it comes to your everyday civil servant. Career employees have faced warning letters, reprimands, suspension without pay, and they've even been fired and debarred so they can't return to government employment. Now, government employees do retain the right to express their opinions on political subjects, and even their opinions on candidates' policies, but they cannot engage in partisan campaigning. So for example, the Office of Special Counsel, which oversees the Hatch Act, has ruled that federal employees cannot wear or display "Make America Great Again" slogans or paraphernalia while at work, because those are associated with President Donald Trump's campaign to be reelected. Those same restrictions would apply to the Biden campaign. So you can't wear, if you got to wear your face mask, now with COVID, you can't have a Trump face mask and you can't have a Biden face mask when you're going to your federal job. On the other hand, the Office of Special Counsel ruled earlier this year that federal employees can display Black Lives Matter symbols and slogans, and they can discuss their support for the Black Lives Matter movement because that is not inherently partisan. And that's really what the Hatch Act is getting at, is inherently partisan activity while you are on the job as a federal employee. The government can also exert limits on certain other types of speech, including commercial speech and false or dangerous speech. Now, government restrictions on commercial speech can violate the First Amendment. The Supreme Court, in a case called Central Hudson Gas and Electric versus the Public Service Commission back in 1980, the court balanced the interests of the government and the interests of the corporation engaging in commercial speech, and determined that any government restrictions must be narrowly tailored to directly advance a substantial government interest. There's a case, Bad Frog Brewery versus the New York State Liquor Board, and that raised the question of, can New York's Liquor Board, which is a state agency, ban a beer bottle that features a frog flipping the bird at you? And New York argued that the image connotes a patently offensive suggestion, and it claimed that the state had a substantial interest in protecting children from these types of, vulgar images and vulgar speech. It was kind of the standard overwrought, but think of the children argument. So New York claimed it had a substantial interest in protecting children from vulgarity, and it banned Bad Frog Brewery's logo pursuant to that interest. So this made its way to the Second Circuit Court of Appeals, which agreed that states do have a substantial interest in protecting kids from vulgar and profane advertising, but the court noted that banning a single brewery's logo did nothing to further that interest, given, and I'm quoting here, the wide currency of vulgar displays throughout contemporary society, end quote. So the Second Circuit determined that any government effort to restrict commercial speech must be part of a substantial effort to advance a valid government interest, and not merely, and again I'm quoting, not merely the removal of a few grains of offensive sand from a beach of vulgarity. The Second Circuit also noted that this New York law was not narrowly tailored. Rather than banning the Bad Frog label entirely, the state could have just required that bottles featuring that label be placed in restricted areas where children were less likely to see it, such as on the top shelf in stores. Other areas not accorded First Amendment protections or full First Amendment protections are speech owned by others and a general category of speech that you can kind of think of as the bad stuff. So the First Amendment does not protect you from infringing on someone's copyright, because in that case you are using their speech or their expression without their consent. So it's not your speech, so you do not have protections in it. The First Amendment also doesn't protect false or dangerous speech. It does not protect slander or other forms of defamation because those are false. It does not protect obscenity, child pornography, or fighting words because those are dangerous. Obscenity is probably the most challenging category because people have different opinions on what counts as obscene. In Miller v. California, the Supreme Court decided that a work is obscene and thus not protected by the First Amendment if the average person applying contemporary community standards would find that the work as a whole appeals to the prurient interest, and the work is patently offensive because it depicts sexual conduct or bodily functions, and the work taken as a whole lacks serious literary, artistic, political, or scientific value. So most art, including popular music, that strikes certain people as offensive to the point of obscene is actually afforded its full First Amendment rights because of this carve-out for works of serious literary, artistic, political, or scientific value. Now in New York v. Feber in 1982, the Supreme Court held that child pornography is not entitled to any First Amendment protection because the government has a very compelling interest in preventing sexual abuse and exploitation of children. So this is a positive think of the children claim. And to ensure that child pornography did not fall into Miller's artistic carve-out, the court specified that child pornography intrinsically lacks artistic value, so it gets no protection. Then in Chaplinsky versus New Hampshire, which was an older case in the 40s, that's where the court set forth the fighting words doctrine. And fighting words are written or spoken words that are intended to incite hatred or violence. In that particular case, Mr. Chaplinsky was handing out pamphlets. He was particularly obnoxious about it. Some of us would say that just being bothered by pamphleteers is good enough for fighting words. In this case, the fighting words that he said were, and I'm quoting here, "You are a goddamned racketeer, and you are a damned fascist." Those would almost certainly not be considered fighting words today, because these doctrines evolve. So any speech that falls outside of one of these narrow exceptions, owned by others, false statements, obscene, child porn, fighting words, any speech that isn't in there is constitutionally protected. It is protected by the First Amendment, regardless of whether it offends anyone. Now that we have run through the Bill of Rights and some limitations on those rights, let's turn to the concepts of due process and equal protection. A year before Brown v. Board of Ed desegregated public schools across the nation, the Supreme Court heard a case called Bowling v. Sharp, and it desegregated public schools within the District of Columbia. And in that case, Chief Justice Earl Warren noted that both due process and equal protection stem from the American ideal of fairness, and these are not mutually exclusive. The Bowling case also introduced the concept of reverse incorporation. So rather than incorporating the Bill of Rights against the states via the 14th Amendment's Due Process Clause, the court in Bowling incorporated the 14th Amendment against the federal government via the 5th Amendment's Due Process Clause. So these concepts of due process and equal protection go hand in hand, and they protect individuals from government overreach. Due process is the concept that the government must operate within the boundaries of the law, and it must provide a fair process before it infringes on any of our fundamental rights, which are also called our liberty interests. Equal protection is the concept that the government must apply laws in such a way that similarly situated individuals are treated equally. So due process is so nice, we've got it twice. It is contained both within the 5th and 14th Amendments, and it is the only clause of the Constitution that shows up twice. So due process is literally the process due to an individual before the government deprives that individual of life, liberty, property, or some other fundamental right. And some of our rights are so important and so fundamental to being an American that to take them away, for some action of the government to take them away, would warrant a really strict standard of review and an explanation as to why the government can take those rights away, if it can take them at all. So before the government intrudes on our fundamental rights, it must provide us with due process. Over the course of common law history, so starting back in ye olde England, fundamental rights are those that have been deemed essential to freedom. And these fundamental rights can be given to people by natural law. So they are kind of just human rights independent of the positive laws that are invented by people in our governments. Or they can be determined by reviewing historical foundations and protections of the right. That's why we go back sometimes to the Magna Carta. Or they can be determined by courts based on what we call evolving standards of decency. So as our society evolves morally, politically, and technologically, we often realize that we have been infringing on the rights of a certain group of people, either intentionally or accidentally, and we decide that it is time to treat that group of people as full human beings. So fundamental rights, they include all of the rights enumerated in the Constitution and its amendments, includes the right to equal protection of laws. Other fundamental rights are things that you can kind of think of as what happens in your private, home almost. That's why I've got the Simpsons house here. Your right to privacy. The government's not supposed to get too involved on who you invite into your bedroom. You've got the right to move about the country and usually the world. It's very rare that the US government tells us that we are not permitted to visit a specific country. It includes the right to contract, the right to get married to anybody regardless of the combination of race and or gender, the right to procreate or not, the right to own property, and the right to access the court system. So these are the rights that have been deemed essential to the American concept of freedom. In addition to our fundamental rights, we also have protected interests. And so, you always hear money can't buy happiness. Well, the Declaration of Independence, which was a more lofty and aspirational document, references the rights to life, liberty, and the pursuit of happiness. But the Constitution, which creates a formal framework of rights, supplements property for the pursuit of happiness. So the framers certainly thought that property was part of happiness. You can buy happiness. It is important to keep in mind that the framers were rebelling against a monarchy, and in a monarchy, holding property is of paramount importance. So based on the Constitution, in addition to our fundamental rights, our protected interests are life, liberty, and property. Now, life is usually not an issue for administrative agencies. Typically, it's only law enforcement, correctional, and immigration agencies that have to worry about unconstitutionally taking someone's life. We are seeing now through the Black Lives Matter movement and similar movements what is, in my opinion, a very reasonable demand that law enforcement provide due process before they take someone's life. If you think about the Black Americans who have been killed recently by the police, Breonna Taylor, she committed no crime. Had she been provided with due process accorded to her by the Constitution, she would not have been sentenced to death. She would be alive. Likewise, George Floyd would not have received the death penalty for passing a phony $20 bill. And Philando Castile committed no crime by affirmatively telling the police that he legally possessed a firearm, and yet he effectively received the death penalty without due process. So we are all constitutionally entitled to due process before the government takes our life. In addition to life, we have a liberty interest. And again, typically this is only an issue for agencies that have the power to incarcerate individuals. But we are constitutionally entitled to due process before the government deprives us of our personal bodily liberty. We also have a liberty interest in our reputation, and this is broader than the liberty interest of not being locked up. So all agencies, not just law enforcement or correctional or immigration, but all agencies need to consider due process before they make any public statements that would humiliate somebody or harm their reputation. This also comes up during internal HR proceedings. If you are suspending or terminating somebody from government employment, the government has to be careful about what it says about its personnel who are being terminated, because you cannot intrude upon their liberty interest in a good reputation. And finally, we have a property interest that covers both tangible and intangible property. So tangible property is stuff that you own and you can touch: your house, your car, your rare collection of mint condition My Little Ponies. Intangible property are things that you have or you're entitled to have, but you can't necessarily touch. Your Social Security or your Medicare benefits, potentially your continued government employment, your professional license. So I have an entitlement to my license to practice law, and the state of Maryland would have to afford me due process before they took that license away from me. Driver's licenses also fall into that category. Public education can fall into that category. And then if the government provides utilities, it also has to provide due process before it revokes utility service, particularly if it's incredibly hot or incredibly cold outside. So the heat of summer, the dead of winter, your government provided utility can't just shut you off without some type of due process. So there are two types of due process: procedural and substantive. Procedural due process focuses on a fair, impartial process, usually some type of adjudication, so some type of hearing. And it's all about the minimum procedural steps the government's got to take before depriving somebody of life, liberty, or property. So if you've got something like your veterans benefits, for instance, and the government believes that you're not entitled to it, it has to follow a process before it takes them away. So you have veterans benefits, the government decides that you're not entitled to them, it can't just yank them away from you, it's got to give you process. And typically, that process due is notice and a hearing. So the person affected gets notice of the government's intent to act and a hearing to determine if the government's action is appropriate. In terms of how much notice and how formal a hearing and when you have to hold that hearing, it really depends on the type of entitlement, right, or interest involved. So typically, the greater or more important the right, the more process is required. And in determining how much process is due, the courts balance the interest of the individual, your interest in retaining your property, the injury that might be threatened by official action. If you lose your VA benefits, does that mean that you can no longer go to a doctor if you can't afford a doctor? It also takes a look at the risk of error through the procedures that the government is using and the value that there might be in additional or substitute procedural safeguards. But it also looks at the cost and administrative burden of requiring those additional or substitute procedural safeguards. So procedural due process really gets down to the question of, is the party entitled to notice and how much? And is the party entitled to a hearing and when? Is it pre-deprivation, before the government takes your right, you got to have a hearing? Or is it post-deprivation, the government can take your right, follow up with a hearing, and then give you your right back if it turns out that they should not have taken it? The Administrative Procedure Act, it sets forth certain due process protections for people whose rights are affected by government administrative agencies. They've got the right to know why the government's taking action. They've got the right to bring an attorney to an agency hearing if the purpose of that hearing is to find facts or discuss complex issues of law. And they have a right to present their arguments, including presenting evidence. So what kind of hearing, when, where? As to where, the APA permits agencies to hold hearings in Washington, D.C., because that's where they're headquartered, but agencies can also hold hearings at their regional and local offices. And the due process clause can kick in and require that the hearing be held in a location that is convenient to the affected parties. So if you live in Texas and you're being adversely affected by EPA action, the EPA can't necessarily force you to go to Washington, D.C. They might have to hold that hearing somewhere in Texas. The bigger question is when the hearings take place. Again, this is the pre or post deprivation. So before somebody is deprived of a right or interest, or after. And to determine when the hearing takes place, agencies and courts look at, is the individual who's impacted, are they going to suffer additional harm if they don't get a pre-deprivation hearing? If your VA benefits are being taken away and you can't afford your medical treatments without your VA benefits, then you will suffer additional harm without a pre-deprivation hearing. Courts and agencies also look at the value of providing additional procedures via the pre-deprivation hearing, as well as the costs and burdens, likelihood of error if there is no pre-deprivation hearing, and the public interest in selecting one or the other, pre or post. Now, pre-deprivation hearings do not have to be full hearings. You can have a limited one and then a full trial type hearing after the fact. If a pre-deprivation hearing is not required, agencies can't just take whatever action they want. They still have to have some type of discussion to determine whether or not they really should be depriving you of your right or interest. Additionally, if the government deprives you of a right or interest without a hearing, without a pre-deprivation hearing, then it must have a post-deprivation hearing close in time, so shortly after it deprives you of something, and that hearing does have to be thorough. A couple of different classifications, job termination and expulsion from public school, those both require full trial type pre-deprivation hearings. If you are simply being suspended from your job or suspended from your school, you get an informal pre-deprivation hearing. Doesn't have to be full trial type. If no other remedy is going to be available to you before, if the government takes a right or infringes on a right or interest, then a pre-deprivation hearing is probably going to be required. Now, that is not the case if there was another form of hearing. If there's a criminal trial and you get your full rights at a criminal trial, an agency doesn't also have to hold a hearing for you because the trial takes the place of a pre-deprivation hearing. In emergencies, agencies can take action without providing notice or hearing, but as soon as that emergency is averted or resolved, the agency has to then immediately give notice of the action taken and provide for a hearing. And emergencies include things like protecting the public health or safety. So for instance, the police can revoke your driver's license during a DUI arrest because they don't want you out there driving drunk, potentially harming other members of the public. Now, substantive due process is different because it's an examination of the individual liberty or property interest or fundamental right at stake. And it's examination of whether the government is unconstitutionally infringing on that interest or right. So substantive due process focuses on our fundamental rights. It is separate from the focus on the process that has to be followed before infringing on those rights. And that is because it is possible to follow a process that is designed to be fair and impartial, yet wind up with an unconstitutional result. And it might be easier to think about this using the legislative process. If Congress drafts a bill and it holds all of its hearings as required, and both houses of Congress pass the bill and the president signs it, then that bill went through the correct process and becomes law. But if that bill, now a law, makes it a crime to attend a Catholic Mass, that law is unconstitutional because it exceeds the limits of government authority, limits in this case imposed by the First Amendment. So substantive due process asks whether there is a fundamental right or liberty interest at stake And if so, does the government's action unconstitutionally infringe on that right or interest? In addition to due process, the 14th Amendment addresses equal protection. It specifies that no state can deny to any person within its jurisdiction, and so this applies to foreign nationals present in the U.S. in addition to U.S. citizens and permanent residents. So no state can deny to any person within its jurisdiction the equal protection of the laws. And as I said, the Supreme Court has found the concept of equal protection is also implicit in the Fifth Amendment's Due Process Clause. So the Equal Protection Clause is concerned with any laws, regulations, or government actions that classify people and then treat them differently based on that classification. Now keep in mind, most classifications do not violate the Equal Protection Clause. We classify people all the time by height, alphabetically by name, by age, drinking age, but also for your senior discounts. We might classify people based on their marital status, married or divorced. We might classify them being Star Trek fans or Star Wars fans. So a lot of those classifications have nothing to do with equal protection. It is suspect classifications that violate the Equal Protection Clause. And a suspect classification is the classification of groups in such a way that indicates that that group of people is being subject to discrimination. What this means in practice is that to affect a suspect class or involve a suspect classification, the law has to target a discrete and insular minority where that minority possesses some type of immutable trait, such as skin color, and where that minority has historically faced discrimination, and where members of that minority are powerless to protect themselves via the political process. Now that last prong, powerless to protect themselves via the political process, is pretty murky, and it came up quite a bit during the debates over marriage equality, because, in our current society, gay people, particularly middle and upper class gay people, are certainly able to influence politics through special interest and lobbying groups, like Human Rights Campaign and what have you. Similarly, Black Americans no longer face poll taxes and are fairly regularly elected to national office. But the fact that things have improved does not outweigh centuries of discrimination that have really entrenched systemic inequalities. And while minority groups are always considered equal under the law, that's just not always the case in the real world. So some examples of suspect classifications would be those based on race or religion. Those types of classifications are immediately suspect. Ethnicity or nationality-based classifications are also suspect outside of immigration or national security law operations. There are also classifications that are not suspect in and of themselves, but they burden a fundamental right, and thus they also violate equal protection. So for example, some states had laws that required divorced people with kids, that is a non-suspect classification, divorced and has kids, but states required those people to get court approval before they remarried. But marriage is a fundamental right. And by making it harder for divorced people with kids to remarry, those laws violated equal protection as required by the Constitution. Now, a big challenge to equal protection is covert discrimination. A law can appear legitimate, but it can actually be discriminatory, either on its face, so as written, or as implemented by an agency. It is very difficult to prove covert discrimination, and there is more than one type. So in the first type of covert discrimination, the law looks legitimate the way it's written, but it is actually discriminatory. And probably the most commonly known example is the US sentencing guidelines, which imposed much harsher sentences for crack cocaine than for regular cocaine, even though these are just two forms of the exact same drug. The difference is that Black Americans were usually arrested for crack cocaine, and white American businessmen were usually arrested for regular cocaine. So it appears legitimate. Oh, one's for crack cocaine and one's for regular cocaine, but it's the same drug. And so, although it appears legitimate, it is actually discriminatory. The second type of covert discrimination, the law itself is legitimate, but the agency administers that law in a discriminatory fashion, usually through what we call selective enforcement. There was an example, gosh, maybe about a decade ago, where there was a Philadelphia swim club, and it denied access to a group of Black students because of possible overcrowding. Concerns about overcrowding in a pool are absolutely legitimate. And if that swim club was denying access to any group that came up in it at that time because of overcrowding, then it would be fine. However, this particular swim club denied access to groups of Black students, but not groups of white students who approached at the same time. Now, one reason that it can be difficult to prove covert discrimination is because showing disparate impact is not sufficient. The party who is alleging covert discrimination has to prove that the law's purpose is discriminatory, or that it was enforced in a discriminatory fashion. So an example of disparate impact is the fact that the majority of landfills, water treatment facilities, waste management facilities, those are mostly located in poor and minority locations. They have a disparate impact on poor and minority Americans, but it is not discriminatory because the siting of those particular plants, treatment facilities, are not intended to discriminate. Since the courts are the ones that enforce our constitutional rights, let's take a quick look at our court structure. At the federal level, we have 94 federal district courts. Those are our trial courts. They are divided amongst 13 circuits. 11 of those are regional, so they're geographic. There is also the DC Circuit and the Federal Circuit. Circuit courts are also called courts of appeals. The U.S. Court of Appeals for the Federal Circuit is for specialized cases, and that includes appeals from agency decisions. So in our court system, cases rise from the bottom up to the top, and policy flows down from the top to the bottom. So you start in your trial court and you work your way up, but it is the U.S. Supreme Court that sets policy, and that flows down to all of the federal courts. So at both the state and federal levels, cases, like I said, they start at the bottom in the trial court. A plaintiff sues the defendant, or in criminal law, the government brings charges against the defendant. Federal trial courts are called district courts. That is usually the case in the states, but just be aware that state names can vary. The loser at the trial court level can appeal to an intermediate appellate court, and the loser is now called the appellant. Federal intermediate appellate courts are called courts of appeals or circuit courts. And that's because back in the day, judges literally rode on horseback around a circuit to hear cases. So that's why we call them circuit courts. And the loser at the appellate level can appeal up to the Supreme Court, in which case the loser is now called the petitioner. So you are petitioning the Supreme Court, and that is because the Supreme Court does not have to hear your appeal. It is discretionary. The highest state courts are usually, but again, not always, called Supreme Courts. In terms of your case citations, if you're referencing a district court or a court of appeals, you actually have to provide that in the citation. But you don't have to designate the U.S. Supreme Court, and that's because U.S. Reports only publishes Supreme Court cases. So this diagram shows how court cases rise to the top of the court hierarchy, both in the federal system and in a typical state court system. Now, I cannot say it enough times, each state has its own court system, so you can never assume that the court systems of one state will exactly match the court systems of another state. One noticeable and sometimes confusing difference between federal and state appellate procedures is the way that cases are named. So in federal courts, the case name stays the same until the case reaches the Supreme Court. So in federal courts at the district and circuit court levels, it is always plaintiff versus defendant. If John Doe sues Joe Smith, the case name is Doe versus Smith. At the district court level, it is Doe versus Smith, regardless of who appeals at the circuit court level. Also keep in mind that a case can be heard twice at that circuit court or court of appeals level. So first, cases are heard by a panel of 3 judges, not all of the judges like we would see with the Supreme Court. The losing party in front of that 3-judge panel can then appeal to the entire circuit court, sitting en banc is what we call it. After that, the loser can appeal to the U.S. Supreme Court, which always sits en banc, all 9 justices at a time. At the federal court system, that's the only time the name might change, because the name of the person petitioning the Supreme Court goes first. So again, if it is Doe versus Smith, all the way up through the courts of appeals, if Doe is the one who petitions the Supreme Court, it's still Doe versus Smith. But if Smith petitions, it becomes Smith versus Doe. In state courts, it's the name of the party appealing the case, the appellant, that always goes first. And so in state courts, Doe v. Smith can become Smith v. Doe, and then revert back to Doe v. Smith. So if you appeal, you lose a case and you appeal, there are several things that can happen. The Court of Appeals, or the Supreme Court, depending on what level you're at, can affirm the decision of the lower court. In that case, the higher court agrees with the lower court's decision. Usually, the higher court will explain why, and that decision stands. The higher court can reverse the decision of the lower court. So it disagrees with the lower court's decision and overturns it, and also explains why. The higher court can modify the decision of the lower court. So the higher court could agree with the overall outcome, but maybe for reasons other than those specified by the lower court. And the higher court can also remand the case back to the lower court. So in that case, the higher court might disagree with some or all of the lower court's decision, but it needs more information. And so it sends the case back to the lower court, which then has to reconsider the case in light of instructions from the higher court. So if a case contains multiple issues, there can actually be multiple outcomes in the same case. The higher court can affirm in part, reverse in part, affirm in part, and remand in part. There can be multiple outcomes. Administrative agency decisions can also be appealed to the court system, to an Article III court. So the U.S. Court of Appeals for the Federal Circuit, that's the appellate court for administrative agency decisions. There is also the U.S. Court of Federal Claims. That is the appellate court for agency decisions that deal with monetary claims against the U.S. government. Most often, but not always, those are filed by government contractors. As we will learn a little bit later, the Court of Federal Claims is not an Article III court, and so its decisions can be further appealed to the Federal Circuit because the U.S. Court of Appeals for the Federal Circuit is indeed an Article III court. Right, so what do courts examine? Well, when they're looking at cases at the appellate level, they're obviously looking at the facts of the case and the evidence, what was introduced at the district court, at the trial court. Appellate courts also look at the terms of the statute, regulations, or constitutional provisions as they're written. So basically taking the words at face value. But they will also look to the intent of Congress, agencies, or the framers of the Constitution in writing those terms. and this allows the legal field to have a vigorous debate over which is better, but courts generally take a look at all of that. They will also make sure that there's compliance with federal and state due process clauses and equal protection clauses, and then just general compliance with other laws. Now, the way that they determine this when they're taking a look is that courts use 3 different standards of review: rational basis, intermediate scrutiny, and strict scrutiny. The rational basis test is most commonly applied, and strict scrutiny is least commonly applied. It's really reserved for reviewing laws that infringe on fundamental rights or that create suspect classifications. So the rational basis test is going to apply to any situation where there are no fundamental rights or suspect classifications at issue. And if a court reviews a law or regulation under the rational basis test, it is probably going to survive because it's the easiest test to apply. Now, interestingly, during the recent same-sex marriage equality debates, a lot of justices, prior justices, judges, and legal experts were actually saying that discriminating marriage inequality, so discriminating against people because they want to marry somebody of their own sex, actually fails even the rational basis test. And that's pretty fascinating because rational basis is usually, the government's going to win. There's intermediate scrutiny. This applies to quasi-fundamental rights. Primarily, it's going to apply to time, place, and manner restrictions on speech. So the First Amendment grants us the freedom of speech, but governments can apply some restrictions on speech or assembly. That's why you've got to go ahead and, get a permit to hold your protest. This also comes up a lot in what we amusingly refer to as erogenous zoning cases, which generally require adult bookstores to be close together in a city. So that's a time, place, and manner restriction. You can only sell your porn at a certain time and in a certain place and, in a certain manner. If restricting time, place, and manner means that the speech cannot take place at all, then that law is going to fail intermediate scrutiny. This also applies to quasi-suspect classifications like gender and illegitimacy. And it applies to the regulation of commercial speech. You can go look up Bad Frog Brewing Company. Its logo is a frog that is flipping you the bird. And there was actually a case on, regulating commercial speech. Was it okay to allow the brewery to keep that as a logo? So that's intermediate scrutiny, but honestly, you don't have to really worry about that because most cases are decided on a rational basis test, and then the handful of really important ones that get a lot of public attention are strict scrutiny. And for strict scrutiny, the law that is infringing on your right has got to be narrowly tailored, it's got to further a compelling government interest, and it's got to be the least restrictive means. So crucial compelling interest is usually something like national security. Most government laws that infringe on fundamental rights that are reviewed under strict scrutiny are deemed invalid, so the courts invalidate those laws. All right, so how do courts decide which test to use? Well, they go ahead and look and see, does this case involve a fundamental right or a suspect classification? And if it does, then the court is going to review the government action and the law at issue with strict scrutiny. So again, fundamental rights, they always require that highest standard of review. The government's got to prove a compelling state interest. It's got to prove that the law is narrowly tailored. So basically, the government's got to have a really, really, really excellent reason for infringing on your rights, and it's got to infringe on them the least possible amount. All right, so that is it for our lecture this week. So because I have not yet returned your first case brief to you, and I apologize for that, I'm actually extending the deadline for case brief 2, and I'm also going to change the case. I'm going to change it to Obergefell v. Hodges, because I want to kind of just stick with this idea of marriage equality. And I will endeavor to get your Loving v. Virginia case briefs back by the middle of this week. So you do not have a case brief due at the end of this week. You do have a discussion. We are going to be talking about the Hatch Act and First Amendment rights. So thanks so much for listening to me. I hope you have a great week, and I will see you on the discussion boards.